the 145(3) case.
I'm sorry, it was squarely raised. It's part of my written submission. It's recorded in the
The
judgment.
judgment records that there was a reference prayed for.
Mr. Venugopal, are you really serious on the plenary objections?
Manoj?
Are you really serious?
Yes.
Are you really serious on?
You just tell us how
Yes,
do you
very-
overcome 145(3)?
Manoj, very serious for the simple reason,
So just point out how do you overcome under 145(3)?
and I'll tell you, Lordships, why. Please turn straight away to the queries. What are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution of India? Now, if your lordships would be pleased to take my written submissions, at the end of the written submissions, which is only 8 pages, I have given a tabulated statement putting the query and the place where in the Tamil Nadu judgment, this query is squarely answered.
Mr. Venugopal, we are sorry, we are not again answering our question as to how do you meet the requirement under 145(3).
But let me answer your
When the
lordships.
learned attorney specifically states
Yes,
that it was his contention that in view of 145(3), the matter should go to the 5 judges bench, and that submission is also recorded in the order.
yes.
Then do you not think that your objection is hyper-technical?
Well, I would have expected him to have argued the matter and placed it, because one has to decide.
Now, please don't interrupt.
One has to decide.
If somebody from one corner goes and somebody from the other corner rises, will not be in a position to complete it. Have some decorum. You are in the court, not somewhere else. You might be used to that atmosphere.
In which case, my lords, one would have expected an argument had to be raised by the learned Attorney General and pointing out to put to the decision of the court that a substantial question of law relating to the interpretation of the Constitution has been raised. Nowhere in the entire judgment would one find
No,
anything
but
to the effect.
the judgment specifically records that he has taken this objection. And if that is not considered, then is it his mistake?
Nowhere does the judgment say so, my lords, with great respect.
Mr. Attorney, where is the submission of the objection in the judgment recorded?
Both in my written submissions and also where the court is recorded.
It's there in 34L. Para 34L has the submission, has the attorney's submission.
Then if the court doesn't decide it, is it?
Deal with it after Mr. Venugopal. I don't want to interrupt you.
I will answer the
query.
question. Is
The
sufficient
lordship's
for the
query.
judge to say it's been raised?
It's been recorded. He's right. AG is right.
34L, my lord,
Mr. Venugopal, can you formulate your objection so that we
Yes.
can consider it?
Para
Yes, sir.
34 small l
34L.
records the submission, which, my lord, I'll just read the
34L
learned
says-
attorney's submission. He submitted
said
that
so.
exposition of Article 200 as done in state of Punjab is sub silentio as the court, while making the said decision, did not take into account the observations made by the Constitution bench. In last, he submitted that the matter may be referred to a larger bench of this court so as to harmonize the etc.
Therefore, that's what he has said. L, which he has referred to, is a page. May I read that, notes? What he has said at clause L. What he has raised, my lord, in clause L,
He specifically raised that it requires consideration by a judge of 5 judges. If the court doesn't consider it,
may,
can
may,
it be wanted for that?
may I just read what he has raised? He has never raised this for 145(3).
Mr.
145(3 is
Solicitor
not
has,
mentioned any.
he might not have referred to 145(3), but he has specifically referred that it requires to be considered by 5 judges.
No, what he has said
I
is
will
this.
not respond. I'll wait.
May I
for
just
my
read, my lord, his clause L. In the last, she submitted that the matter may be referred to a larger bench of this court. Larger bench would be 3 judges, so as to harmonize the observations in BK Pavitra, which is 2 judges, and Valluri Basavaya, which is 5 judges, and State of Punjab.
Mr. Venugopal, can you just formulate your submission so that we can consider what is your
My submissions are this. But please see his queries 1 to 11. Each one of these is covered by the judgment in the Tamil Nadu case directly. Now, once, my lords, a judgment covers these issues 1 to 11, these issues are no more res integra. And a series of judgments starting with the 9 judges in the St. Xavier, Ahmedabad St. Xavier case, plus, my lords, the judgments in natural resources, Kaveri, Gujarat Assembly, have all said that if an issue is already decided by the court, no reference can be asked in regard to these issues because they are no more res integra. Unequivocally, because if your lordships were to decide these issues in a 143, the result would be that so far as your lordships are concerned, your lordships are equally bound, along, my lords, with all under 141 by judgments delivered by your lordships.
So the 5 judges bench is bound by the judgment delivered by the 2 judges.
Unless your lordships overrules it in a case under 32 or, my lords, 136 or 131.
Okay, we'll
Unless your
consider
lordship
that.
overrules them. Now, what he is asking for is for a lordships, my lords, by reason of
Mr. Venugopal, we have understood your submissions. Yes.
Yes.
Now let Mr.
all right. Therefore, my lords, by reason of the reference, your lordships at the bench of the Supreme Court is being asked to sit in judgment on another bench of the Supreme Court, which has already decided.
Yes.
And therefore, 143 is sought to empower your lordships to decide, my lords, these questions. This, I say, my lord, is wholly, my lords, outside 143, because your lordships can't touch, my lords, a judgment in 143, which has finally decided these 11 issues. Now, the real reason, my lords, your lordship will find is nowhere, my lords, in this reference is, my lord, the Tamil Nadu case referred to. And this reference is sought within 1 month and a few days after, my lords, the judgment in Tamil Nadu, without seeking review, which, my lord, according to me, the government of India was bound to seek review. Your lordship may kindly note that so far as the President of India is concerned, under Article 74, the President is bound by the aid and advice of the Council of Ministers. No area of discretion is left.
Yes.
No area of discretion is given to the President under Article 74. The President has to carry out whatever is advice given by the Council of Ministers. Therefore, in substance and in effect, this reference is by the government of India, but by my lord, mentioning the president as a referring authority, well, that's what Article 143 requires. So please remember that each one of these is an attempt by the government of India, without filing my lord's review, to overturn my lord's, if it is permissible under 143, to my lords, the judgment, my lords, of the by Supreme Court, which under 141 binds all. Therefore, I come to the proposition that a judgment of the Supreme Court is law under Article 141.
Yes, Mr. Venukumar, we understood that. Now let Mr. Dr. Singh.
No, only one more, Millards. Only one more. That is under 141, Millards, they are bound by all the law laid down by the Supreme
That
Court.
you already said.
Yes,
We
but
have recorded that.
143 is only an opinion. And even if your lordship gives all these opinions, and to complete, my lords,
Yes, we have recorded that. Now let
all
Dr.
right.
Singh be making.
Therefore, my lord, this judgment will still stand,
Yes,
notwithstanding the
yes,
opinion
Mr.
under
Venukumar, we
143.
understood that submission, yes.
Very well, my lords. Very well.
Yes, Dr. Singh.
Yes, sir.
Only 5 minutes left. No, we are bound by the
I'll
time.
take only minutes, 10 minutes.
No, we have told you that half an hour for you and half an hour.
I will not exceed, but give me some 10 minutes. I'll not go to exceed. Now, let's please keep 531 open. Allow me to do some speed talking and speed reading.
531 off?
Volume 5.31 of the written submissions. First, fellows, the point-wise answer to my Lord, the Honorable Chief Justice question, then give me 5 minutes to elaborate.
Which volume you want us to?
5.31.
So that's your written submission.
Yes.
Yes, we got it.
In that, fellows,
Yes, sure.
5.31.
Page?
No. I'm sorry, fellows, mine is volume 2. My written that 5.31
No, 5.31 is the judgment of the two judges.
with that my written submission, volume 2.
Came last night, it was 2 point.
Volume 2. So that is the judgment. Please keep volume 2, simple volume 2, which is my written submission at page 4. These two will also keep open. I appear for the state of Tamil Nadu, the only state which went to the Honorable Division Bench, and we succeeded in the order on which now the advisory opinion is sought. If my Lord will keep my written submissions open, in volume 2, at page 4. Now, the point-wise answer to my Lord's queries before I elaborate, because there are two important judgments, the nuance of which your Lordship will profit reading. One, there is, and this is all said by your Lordships in the context of various judgments. No intra-court appeal is allowed. Point 1. Point 2, advisory cannot be a substitute for review. Point 3, advisory
So one minute, no intra-court appeal.
directly or indirectly, disguised or not.
Yes.
Number 2, no 143, not a substitute for review.
That already.
And
Venukumar has submitted.
review admittedly not filed in this case. Not filed. Number 3, 143, not a substitute for hurrah and curative. And no curative obviously filed in this case. Number 4, if my Lord will turn to page 5 to save time of my written submissions, 5 and 6 have an issue-wise delineation of each issue raised in the reference, which para of the division bench decides this. This is extremely important. Lordship will pardon me for saving time, and I'm not taking your Lordship may test it by going to any one para. For example, issue number 1, para 434.1, 434.2, 434.7. Directly deal with it in the conclusions. The reasoning is in the earlier paras 180, 185, 187, 189, 194, etc. Just because I don't have time to read them, please assume in my favor that they deal with it exactly. Every issue, barring issues 11, 12 and 14. Barring 11, 12 and 14, everything is directly covered. Now a word on these 3 issues when I come to the nuance then. 11, 12 and 14 do not really arise because 11, if you will see the issues, is not a standalone issue and the others are peripheral issues. 12 and 14, in fact, not decided because it didn't really arise. They applied the Punjab judgment in the division bench. So substantially every issue para-wise is covered. Now, Malas, the nuance. Kaveri is clearly on point in my favor. But a nuance is added by 2G. Naturally, these two judges, Lordship will spend 5 minutes on, otherwise Lordship will not get a complete picture. Now, my learned friends will rely on parts of 2G, so let me give Lordship the point, which is also my Lord Chief Justice's query, and then read those parts. What happens is, Malas, if a bench is hearing a matter, if it decides to refer by taking a view on 145.3, it can refer, no problem. If this bench decides the matter and chooses not to refer despite a submission in para 34L by him, then, Malas, in an appropriate subsequent case, unrelated to this case, unrelated to the list between parties A and B in this case, in a matter between C and D in a subsequent case, your Lordship may or may not refer the issue, not the list. However, the A and B decision, where it is not referred, cannot be touched by a so-called advisory view of 143, because that would be subversive of every principle your Lordship follows. Now, another nuance. That is what this 2G made, very fine nuance. 2G says that you can have a different view on the law, which is what my Lord the Chief Justice is asking. So, in a C versus D case, the law may change because your Lordship takes a different view. But same 2G mentions that you will not change the list of the decision between A and B in the first case, even by changing the law subsequently. Now, another nuance, very important. In the present case, if your Lordships allows this the advisory to proceed, your Lordship would be, your Lordships cannot give, even if your Lordship wants, your Lordships cannot give a judgment. Assume your Lordship allows the advisory, that the A and B, which is Tamil Nadu, A and B in this case is Tamil Nadu, stands as it is, and the law for the rest of the country will be C and D. Here, the nuance, that is one of the two words used in 2G, is view of the law and the decision in the case. So, decision of the case, 2G Kaveri 5 judges say, cannot be changed. The view of the law can be changed in a subsequent order. Unfortunately or fortunately, in my Tamil Nadu case, if your Lordship is persuaded to take a different view in 143, both the decision in Tamil Nadu changes and the view of the law changes, which is not permissible. Now come to all of those two judgments. Come to Kaveri first. This is the fastest I can do it, but I'll be very fast. 5.14 is the volume. 5417 is the case. Please keep these 8 principles in mind, because this is important when your Lordship reads these two judgments. Otherwise, these are repercussions. Your Lordships is being asked, and let's be very clear about it, without any camouflage disguise, to change the decision, the merits of the decision, the content of the decision between A and B, and not in a subsequent decision, because there is no way your Lordships can change the decision in a subsequent decision without affecting this decision of Tamil Nadu. So it's purely appellate, howsoever nicely you may couch it to a 143 court. And that's a very serious, subversion of Supreme Court discipline, Supreme Court integrity, Supreme Court institutional integrity. These are not rules made just like that. The Lordship has so many, suppose this is wrong, in an appropriate case, your Lordship may refer it. A constitutional bench may sit. But the law will not change for the parties who took it to the other division bench, because that is concluded. It is inter partes. It is final. It is unchangeable unless in review or curative.
Yes.
The entire concept of stare decisis will be completely subverted,
Here is the question formulated that we should set aside a particular judgment.
Yes.
We are proceeding on the premise, as we are also sitting in appellate court. We know distinction between 143.1.
Yes.
We know the scope of 143.2.
Yes.
We know Kaveri and 2G stand, the distinction drawn. We are not here on 131. We are in within the parameters of 143(1). And the only issue is that whether the questions raised have been answered or not.
So may I answer? May I answer my last question?
Except for
May I answer my last?
3G, except for the 3G decision, the primary distinction between an adjudicatory decision by virtue of judgments stands on a completely different footing from that of an advisory and consistently
That's my
has
submission.
held.
That's my submission,
Therefore, only nuance that has been brought about in the 2G judgment.
which is what I'm coming to straight away. But let me just take 30 seconds to answer this Suryakant's query.
Touch that judgment.
So let me answer Justice Vikas. This is the important nuance. The nuance of 2G is that the phrase, these are not my words, the Supreme Court words. The decision cannot be changed. The view of the law may be changed. Right, Wallace? No, just give me. Now let me answer Justice Suryakant's query. No, just let me answer. My Lord Justice Suryakant says to me that we will not be touching that decision. Unfortunately, Malas, this is one rare case where both the decision of the case and the view of the law fuse. Let me explain that. There is a complete intersection. Your lordships can't do one without doing the other. And if one is prohibited, the other stands prohibited. Your lordship, all the questions except the peripheral ones 11, 12, 14, if answered other than the way in which the division bench answered it, will constitute a change of law, but a change of law also in the decided case of Tamil Nadu. Because for the simple reason, your lordship's advisory law, which is binding, all admit that your lordship's advisory.
But argument is to accept it. Once there are judgments by court, then everything should stop at that.
No, Malas. Your lordships may find, for example, I mean, this may sound technical.
43(1)
No, that will-
definitely not binding. It is purely advisory in nature. Let's be very clear about
No,
it.
Malas, your lordship's law says that once your lordship delivers judgment,
But
then it is law of the law binding. No,
by
Malas.
a larger bench.
No,
It will
Malas.
be done by a larger bench.
Once your lordship delivers 143, it's a question directly arising, I'll give the judgment.
Yes, that.
Your lordship's views, because your lordship is the Supreme Court, I can't seek your lordship's advice and disregard it. I can't seek your lordship's advice and disregard it.
The pre and post constitution principles are well settled.
Yes.
143(1) or a principle which was earlier to that effect, it is advisory in nature, purely advisory in nature, may or may not be accepted by.
No, Malas, that's not the law. Unfortunately, that's not the law, Malas. Unfortunately, I would say it's not the law because your lordship doesn't give advisory jurisdiction in futility.
More than 40 minutes now.
No, Malas, but
So the timelines have to be followed.
Malas,
You should have decided between you and Mr. Venugopal. That's true.
Malas, therefore, let me just now turn to, so let me say this, your lordship's view, whatever your lordship view takes in 143 is binding. Let's be very clear on that. Second, your lordship's, Malas, is not, to answer the Honorable Chief Justice, this is not perennial. A matter is referred, the law will change for the future. If a matter, Malas, to give a small example, Malas, Honorable Chief Justice, remember yesterday a matter came. Suppose in an appropriate matter, your lordship refers it. A constitution bench constituted by my lord's reference in that case may decide the law ultimately. It can't be in 143. We are discussing maintainability of 143. 143 is not maintainable. Now turn to Kaveri, Malas, very quickly. Malas, Kaveri, just turn to para 37 at page 8. I'm sorry, Malas, I'm sorry. Show me the marked copy. Well, Zurbalos turn to 19, para 19 at page 5429.
Of the judgment, well.
Yes, that is volume 5.14. 5.14. Well, otherwise, kindly consider the institutional implications for having advisory jurisdiction on a matter which will change the decision between parties. It becomes a pure intra-court appeal. It becomes a pure review. It becomes a pure curative.
Simply you are proceeding on assumptions.
No, in
Why
the
are you
event
proceeding on assumptions?
no, I'm saying in the
The
event of lordship
reference will
accept.
be answered, whatever we, how do you think it's going to change the decision
No, Malas, with respect.
already rendered by the division bench? You are proceeding as if the judgment will automatically be annulled.
With respect.
That's not right.
No,
Why are you presuming on that?
No, Malas, I'm not presuming. Kindly give him.
That's how you are proceeding.
No,
You are
I am
based
saying,
on that
no,
assumption.
we are testing maintainability, Malas. We are testing maintainability, right, Malas? For maintainability,
You are relying on which judgment that it is
if I win in the merits,
Come to the point, please.
well, if I win in the merits,
Come
nothing
to
arises.
the point, you show us one judgment,
Yes.
which says that once there is a judgment of a division bench, the reference under 143 is not tenable.
Kindly let us first see this judgment. Because we are talking about advisory. Come to para 19 at page 5429. 5429. Changes can be made, Balas, only in another matter for the future, not Balas in an existing case.
So that's the issue. We are not deciding as to whether Tamil Nadu judgment is correct or not. We are not deciding that issue.
In
We are only answering the reference made by the president.
But in the event your lordship's answers are not consistent with the Tamil
Yes,
Nadu
we are not
matter,
concerned with
then
that.
it becomes a different matter.
We are not concerned with that. It's
Kind-
an advisory jurisdiction.
Very well. Let me just read first Kaveri.
So that judgment which says that the reference is not tenable once there is a judgment by
Well,
2 judges or 3 judges.
Yes, yes. Let me show whatever is there very quickly. Two judgments only. Balas. Come to 19. Where Balas, the tribunal held against Tamil Nadu, the Supreme Court allowed the appeal in 19. Ignore all that. And come to Malas. Straight away para 25 where Karnataka instituted a suit. Let me come to the relevant part. Give me the relevant para. Straight away 83 Malas.
Para 83.
83.
83.
Yes. The
This court by its decision of April, Justice Nath has got it. Justice Chandogre has got it. This court by its decision of April 26, this April 26 is para 19, my lord may write on the side, para 19, has held as pointed out that the central government had made a reference to the tribunal for the consideration of the claim for interim relief prayed for by the state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request being a part of the reference itself. Implicit in the said decision is the finding that the subject of interim relief is a matter connected with the relevant water dispute. Now see from here, Malas. Hence, the central government could refer the matter of granting relief for adjudication. Although this court by the said decision has kept open the question whether the tribunal has incidental, ancillary, inherent or implied power to grant interim relief when no reference for grant of relief is made, it has in terms concluded the second part of the question. This was the earlier judgment of the Supreme Court. It has in terms concluded the second part of the question. We therefore cannot countenance a situation where question 3 and for that matter question 1 and 2 may be so construed so as to invite our opinion on the said decision of the court. That would amount to our sitting in appeal on the said decision, which is impermissible for us to do even in adjudicatory jurisdiction. Nor is it competent for the president to invest us with an appellate jurisdiction over the said decision through a reference under 143. Mr. Nariman contended, however, that the president can refer any question of law under 143 and therefore also asked this court to reconsider any of its decision. That is a direct argument. 143 is quoted. 85. In support of his contention, he referred to Delhi laws. Next line. For the reasons which follow, we are unable to accept this contention. In the first instance, the language of 143.1, far from supporting Sri Nariman's contention, is opposed to it. The said clause empowers the president to refer for this court's opinion a question of law or fact, which has arisen or is likely to arise. When this court in its adjudicatory jurisdiction pronounces its authoritative opinion on a question of law, it cannot be said that there is any doubt about the question of law or the same is res integra, so as to require the president to know what the true position of the law on the question is. Directly on point with this. The decision of this court on a question of law is binding on all courts and authorities. Hence, under the said clause, the president can refer a question of law only when this court has not decided it. The query asked from me, Mills. Secondly, a decision given by this court can be reviewed only under 137. When further this court overrules the view of law expressed by it in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decisions. 5 judges are saying this was. It does so in exercise of its inherent power only and only in exceptional circumstances, such as when the earlier decision is A, per incurium, or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. Under the Constitution, such appellate jurisdiction does not vest in this court, nor it can be vested in it by the President of 143. To accept Sri Nariman's contention would mean that the advisory jurisdiction of 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive is a power to ask. If such power is read, it would be a serious inroad into the independence of the judiciary, because the judiciary includes that division bench, this court, everybody. Next, 2G nuance, because that is the main thing which is alleged to have diluted it. Turn to 2G, which is at page 8123 of volume 5.21. Volume 5.21. So this is crystal clear. Some nuancing was done in a subsequent judgment. So let me place that. 5.21, page 8123. Justice D.K. Jain wrote the main judgment, Willis. There's a concurrence, but I'll only read Justice Jain.
Para 64, 65.
No, but that's correct. That's correct. But there are one or two more paras, Willis. 8157, it starts. Would my lords come to 8176? Before I sat down.
Yes.
May I invite my lords to 8176?
Yes.
The principal objection to the maintainability of the references, it's an indirect endeavor to unsettle and overturn the verdict in 2G, which is absolutely impermissible. The stand of the objectors is that 2G case is an authoritative precedent in respect to the principle or proposition of law that all natural resources are to be disposed of by public auction.
Right.
Now, Malis, remember, Malis, in this case, in the Constitution bench, the only issue was whether only way of disposal is auction, because only word is important. Otherwise, it's okay. They were considering an issue not really considered by the earlier bench. At the outset, we may note that the Attorney General has more than once stated that the Government of India is not questioning the correctness of the directions in 2G case. Kindly mark this. No, learned AG is certainly not doing it here, but I mean, this is the law. This is why your lordship doesn't open a decided case. This is what Justice Suryakant is saying, we're not going into the case, but indirectly your lordship is invited to go into the case. That's the whole contention. So here in that case, the learned AG is not questioning the correctness in the 2G case insofar as the allocation of spectrum is concerned. And in fact, the government is in the process of implementing the same. That's not the case here. That's why 2G nuance is not against me. 2G held because another question was raised. Only way of disposal is auction, which was decided anew. It was not a decision on the old matter at all. Therefore, in the light of the said statement, we feel it would be unnecessary to comment on the submission that the reference is an attempt to get an opinion to unsettle the decision and direction of 2G. Nevertheless, since in support the opinion of Kaveri is cited, therefore we will deal with it. Now come to Balus para 42.
So you can come straightway to para 65. That probably answer what you are.
True, Malus, just 5 minutes extra it will take. I'll just, because otherwise, Malus, just 5 minutes extra it will take. 42. 42. Now, Malus, Kaveri is cited over 4 paras. I will not read it. My lord is right. To say that there is no intent in 2G to overrule or dilute Kaveri. Don't read, Malus, 5 judges in 2G to intending to overrule or dilute Kaveri. Nowhere is there an intention. Now come to Malus. The findings of Kaveri are reproduced in 42 and 43, fully, 42 and 43. Then comes the heart of the distinction, which is between view of the law versus decision of the case. Come to 43 verse. 45. 45. That's the heart of the nuance. Please apply the nuance in another case. Not in this case, Willis, is what I'm submitting. The main emphasis of Mr. Soli Sorabji, do my lords have 45 Willis? May I read? Was on the second part of para 85, which according to him prohibits this court from overruling a view expressed by previously. We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches of these two questions. These words are sometimes used interchangeably, but not here and above. We believe that Justice Sawant consciously draws a difference between the two when further this court overrules the view of law after discussing the case of a decision. Then come to 47 to save time, although 46 is important also. Blacks explains the difference. 47. Therefore, references in para 85 of Kaveri to decision and view of law must be severed from each other. The learned judge observed that in a case of a decision.
Therefore, what we'll be doing is expressing a view of law.
Correct.
Not a decision in Tamil Nadu case.
Correct. But unlike this case, this is very important query from the Chief Justice. Unlike in this case of 2G, where the issue by the earlier bench was auction and the issue separately newly
This
raised.
is specifically answered in para 65.
Let me just read first that. Now, 47, my lord, is noted. 47, my lord, is noted.
Yes.
Now, just come to Malas. 48 for a second. Let me first read, then I'll make my comment. The first limitation is that a decision of this court can be reviewed only under 137 and curative and no other way. I'll leave that, Malas. I'm doing speed reading. I'm not. Please note the principle of Kaveri is reiterated. Now, Malas, if you say per incurium or Malas completely different, the burden obviously lies with the state. Now come to 49. 49 is the conclusion on Kaveri, which is decision versus view. The conclusion is 56, Malas. The problem is that your lordships, try as you might.
Why don't you come to 65? It's directly answered. Not necessary that all those paragraphs, small 5, your junior have to be read.
No, Malas, I'm not even reading half of them, Malas, I can assure your lordships. 63, Malas, and then 65. From the aforesaid analysis,
Yes.
it is quite vivid that this court would respectfully decline to answer a reference if it is improper, inadvisable, and undesirable, or the questions formulated are purely socio-economic or political reasons which have no relation, or are incapable of being answered, or would not subserve anything, etc. Or it is already decided the question referred. Already decided the question referred. That's an important sentence in 63. Then, Malas, come to 65. We are therefore of the view that as long as the decision with respect to the allocation of spectrum licenses untouched, that was the decision of the previous court.
Understand that.
This court is within its jurisdiction to evaluate and clarify the ratio of 2G. For the purpose, it needs little emphasis that we have jurisdiction to clarify the ratio of 2G, irrespective of what we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to what has been enunciated in 2G cannot strike at the root of the maintainability. Consequently, we reject the preliminary. Right, Wallace? Let's apply this. I have no problem. The problem between this case and my case, the difference is that in my case, if your lordship differs with the heart of the reasoning of the previous judgment, your lordship will be disturbing the decision of the case also. In my case, unlike this case where the decision of the earlier court was implemented in letter and spirit, but the law for the future with only one question was changed. Is auction the only way of disposal? The word only was said, no, there are other models of disposal. That's about it. That's, if your lordships can find a way without disturbing Tamil Nadu to reset the law, I could have no problem. I can't. But according to me, the nature of the case is such that your lordships would have to disturb the decision inter parties adjudicated between the parties, without which your lordships can't do it. That's the also.
Mandamus or whatever, if you call it a mandamus, then the declaration
Yes.
that followed in that case has actually happened. So therefore, the question of our opinion having a bearing on a decision taken does not apply here. It's only an opinion. And we have seen in many cases, in a subsequent case, when you refer an opinion of a court and ask the court to take a different decision as against the previous one, many a times the argument was that this can't be relied on because it's only an opinion. That is what would happen. If somebody would, if somebody would argue on the basis of a decision rendered on an opinion,
Two things.
then it will be only.
Tamil Nadu, the governor is supposed to, I'm giving a very practical example, is supposed to do ABC. He's supposed to decide in 3 months. Your lordship's law tomorrow will change it for Tamil Nadu also in the future. That's about all there is to it.
Yes, thank you.
Obliged.
Anybody else?
I don't want to argue. I want just one sentence, because we in government made the reference in 2G. Therefore, I just want to explain the historical context, nothing more than that. What happened was that the principle of law decided in 2G was that natural resources must be auctioned. So that happened as far as spectrum is concerned. The difficulty was that there were Mines and Minerals Act, LPG, land, other resources. So the question arose, should all natural resources be auctioned? And the reference was only to that extent, that forget about 2G, that we are following the judgment. Will other resources also follow the principle of law, namely all natural resources must be auctioned? That's how Muller's 2G was decided. Just that historical context, but there's nothing more than that.
Yes. No, sorry. Yes, Mr. Attorney.
Just note 150 and 152 also. Don't, I'm not reading, just note it for your lordship notes first. 150 and 151 at the paras of this 2G.
First, to set the record straight, your lord. Couple of submissions I would like to make. I'll place before your lordship the written submissions placed before the Tamil Nadu bench and very specifically refer to 145. Because there are judgments of larger benches which are dealt with the question of 200 and 201. So that's why, but then the judgment does not fully record the entirety of my submission regarding 145.2. So we are specifically referred to 145.3. The last paragraph 11 of this. Page 7, paragraph 11. Can you read it? Having regard to the importance that the scheme of Articles 200 and 201 play in the fine and balanced constitutional relationship between the elected legislature and the governor, it would be of utmost importance that the matter must be heard by a constitution bench, as already outlined above in terms of Article 145.3 of the Constitution. This submission is being made with a view the divergent perspectives available in the reading of so-and-so are reconciled, and the scheme of Articles 200 and 201 are duly delineated. In particular, the Constitution Bench judgment of the Honorable Court, Union of India versus Valluri Basavaya Chowdhury, is kept in mind as the said judgment propounds one point of view as regards the process of exercise of duty by the governor in Article 200. You don't want anything more to persuade the court to go under Article 145. Now, let me try to, the 2J judgment has brought in very important perspectives on, I understand if Article 143 is not comparable to any of the other jurisdictions conferred on the court. It is the power and authority of the president. The authority and power of the president is not comparable to, say, 131, 132, 136, etc. They're all jurisdictions conferred to the on the court. But the president, Article 143 says, if it appears to the president that a fact or a question of law is arisen or is likely to arise under public importance, the president is therefore the master of Article 143. And in the course of therefore requesting the court to give an opinion on this question, the court may dwell into the questions. The court may also go into any previous judgments of the Honorable Court and may either agree or disagree. But there's nothing like a threshold injunction against the court to say that we'll not get into Article 143 reference at all. You can't read that limitation in injunction Article 143. And none of the previous reference, 15 references have come before the court so far, right from M.S.M. Sharma case onwards, Keshav Singh case onwards. The court has gone into previous judgments, but they may disagree or you may agree. So that's why in the 2G case, as the learned solicitor will talk to your lordships, the view of law, the state of law, and the decision. It is being told to your lordship that in this particular case, there's no demarcation, the lines are very, very blurred. Therefore, the both are so intertwined that you can't entertain this 143 reference. I think that's not correct. Even if it is so, the question is whether under Article 143, what the court will do to enter into the questions, answer a question, decline to answer a question, all that will be matter of practice or procedure of the court. In a given case, if a public importance, the court will say, we depart from the practice because it's an important question of public importance, and we'll probably look into the judgment 1, 2, 3, 4, 5. Therefore, there is no inbuilt limitation in Article 143, either that will bind the court under Article 143. Look at your old precedents, they are binding on you. 143 does not admit of any of those limitations. Therefore, what you could later argue saying this question need not be answered for good reason because some other judgment has answered it. That's a different way of putting it. But to say the court will not even enter into all of them. I think therefore 143 does not admit of that. I later place your lordship the very first important scheme of Article 143. I just thought as a therefore, I would say that given the importance in the scheme, in the constitutional scheme of Article 143, the court will probably, to repeat, can even depart from its earlier precedents and how the court will order its practice and procedure of deciding matters under 143. There's nothing like an inflexible rule. Then it will ultimately, if there's an inflexible rule, then the presidential referendum, the president being master of a referendum 143 will completely lose its essence. The court may ultimately say we agree with the judgment. But before that, to say you cannot even go to the extent of saying we agree, disagree, I think cannot be read into Article 143. The Kaveri water disputes brought is a very important distinction. The 2G notices that decision of law and then the view of law as against the particular a decree or a judgment inter partes. In a 143 reference, the court does not enter into merits inter partes. It's not a list between the parties at all. Parties can be heard in a 143 only for the purpose of assisting the court as to whether a particular question can be answered or not. Beyond that assistance, which parties can lend to the court under 143, the court will probably not say, I'll be heard on the maintainability. I think even the idea of maintainability is wrong in the context of 143. A maintainability issue can arise only when there are jurisdiction of the court. Article 32, 226, 131 review. Is it maintainable? If have you complied with all the preconditions of maintainability, then maintainability comes in. 143 does not admit to the concept of maintainability at all. So therefore, urge your lordships to be given all those 15 long precedents.
It's not one of the foundational principle of 143, Mr. Attorney, that when he talks of a question of law, has a reason. These are the preconditions. A
That's
question
right.
of law or fact has a reason. That means a question of law that has not been answered in the past. Therefore, the question of law that would arise for 143 one will be the one which has not been answered by this court first. And therefore, that question is coming first time to be answered.
Yeah.
So 143 one jurisdiction will always be at least guided by this principle.
That's true. But therefore, 143 conditions, if you're satisfied, your lordships will go into entering into the question of answering those questions. So even if there is a field occupied by a particular judgment, but if the in public import, the president field, I have a constitution-based judgment, I have a 7-judge judgment, I have a 3-judge judgment, I have a 2-judge judgment, which is the one which governs me. Therefore, on a question of law, if there is no authoritative pronouncement or a conclusive authority, the conclusive authority proposition related in the Bala Sahib judgment, give that reference. Therefore, there is no conclusive authority in that question. And there is a difference of views, 7, 5, 3, 2.
To get into the question as to whether the conclusive authority exists or not, then there is a problem. Opinion, if you are asking, it's an opinion, it's all right. No, not every question also need not be answered.
I'm only trying to point out that when you're talking about a question of law, is there a field occupied by a judgment? And therefore, once it is occupied by a judgment, the court will not enter into 140 reference at all. Therefore, in Kaveri, followed by 2G, it says there is a decision of a state of law. I'm going to probably tell you the state of law is a very important concern for the president. I have so many judgments on my table. Which is the correct state of law? 5, 7, 9, 2, 3. Therefore, if a judgment which is a bench of 2 judges, am I bound by it? I am not trying to say that you will overrule it as a review or an appellate jurisdiction. These are all limitations which the court will ordinarily build into Article 143, where we will not ordinarily say review them. Very simple. If your lordship only look at a later point of time in the Tamil Nadu judgment or the Punjab judgment, we'll be easily able to convince your lordship that the line can be comfortably drawn between what on a particular set of facts the court drew some conclusion. We're not talking about those conclusions in a particular set of facts. We are talking about the state of law, the view of law. The 2G judgment, therefore, opens up an important door for an Article 143 consideration. And I would very humbly submit, these doors probably will be kept more and more open as and when the president comes with issues of public importance. Come. Just 1 second, please. And also to answer an objection raised by Mr. Venugopal, that we are not referred to the judgment in the recital of the reference. He didn't argue. He didn't argue. Very. Because the 140 reference is a sui generis, and it is not akin to a pleading in a petition, writ petition or a suit. So what the president thinks is advisable for to seek a reference before the honorable court and seek his opinions on the questions referred to. There is no one particular form to be prescribed. You can't, probably the president's hands tied by forms and precedents. So it's only the ultimate test will be, will the court enter into answering a reference because of the importance of the questions raised? And if the field is, even if the field is occupied to some extent by some judgment, the court will enter into the reference and probably agree with any one of the judgments to occupy the field. That will be a later point of time.
I'll take only 10 minutes, Malus.
Attorney,
Your Worship, please.
three questions. Apart from the various references that you have made, you will also have to sometime answer why 145(3), though you made a request, it was not accepted, that's a different matter. That will not give rise to a need to ask for an opinion on that, a view. Second is a larger question about 142. What's the need for it for an opinion on the scope of 142? Third, 131 also doesn't arise at all. Why should we answer 131? These three questions.
We will answer that.
Keep it in mind. Whether we should get into those three questions, you will have to answer.
We will address your lordship on the importance of this question. You want to raise the importance of the question. Because the reference has been shaped after a considerable application. So the importance of the questions are arising because what a particular judgment has done is the correct view of law. Therefore, we're on the correct view of law on particularly the scheme of Articles 200 and 201. Everything hinges along the 200 and 201 scheme. So probably you'll also, when you take into the question, you'll also probably persuade that as far as that's concerned.
I'll just take 10 minutes, Malus. Lord, first of all, Lord, Article 143 Lord, needs two contingencies for the Honorable President to exist. A, the question of law has arisen, and B, a question of law is likely to arise. Lord, that is number one. And my Lord, I'll read only few paragraphs from 2G judgment, my Lords. The real, my Lord, issue is, kindly see the importance and significance of this reference. My Lord, there are in all 15 references made by the Honorable President to this court. My Lord, all were with regard to a particular issue, whether the tribunal has the power, whether a particular bill is repugnant to the central legislation, etc., etc. This is for the first time where the Honorable President has felt that there is a functional disharmony which has arisen and which will arise because there has been no authoritative judicial pronouncement except, my Lord, the judgment in question in case of Tamil Nadu, where one organ of the state fixes time schedule for the another organ of the state and also provides for the consequences of deemed assent. My Lord, that is the reason why, my Lord, this judgment, this reference itself is a sui generis reference where the Honorable President is pleased to request your lordships to advise her that there is a constitutional problem a constitutional functional problem. How the president would act, how the governor of the state would act. What are the contours of Article 200, 201, and my lord, the president's power of assent under Article 111. Now, please see, my lord, in case of 2G, my lord, there are two distinct factors, and still the court has laid down the law that reference is maintainable. A, my lord, if your lordships can see, my lord, the question, your lordship did not read the question. The questions which were referred for your lordship's advisory jurisdiction, one of the question was whether judgment of two honorable judges reported in so-and-so lays down the correct law. It was a direct, my lord, as if it was an appeal. So the principal argument against the maintainability was with regard to whether this court would exercise one advisory jurisdiction virtually sitting in appeal, because one of the questions was so framed. Lord, now in this context, Lord, please come to para 48.2, Lord, of the judgment in 2G. Lord, that is page 8181, volume 5.21, page 8181. 48.2, my lords. Lord, your lordships would kindly bear in mind, Lord, your lordships do not generally go into a judgment already decided, not as a jurisdictional issue, that 143 does not permit you to do that. It is a self-imposed restriction that while exercising advisory jurisdiction, we will not go into the question of whether one particular judgment is rightly decided or wrongly decided. But in 2G, my lord, your lordships have said that even that is permissible. Now, please come to page 48.1 and 48.2. 48.2, my lord. The second limitation, a self-imposed rule of judicial discipline. Your lordships have, my lord.
Yes.
The, my lord, it would be page
8181.
8181, my lords. The para 48.2, the second limitation, a self-imposed rule of judicial discipline, was that overruling the opinion of the court on a legal issue does not constitute sitting in appeal, but is done only in exceptional circumstances, such as when the earlier decision is per incurium or delivered in absence of relevant or material facts, or if it is manifestly wrong and capable of causing public mischief. For this proposition, the court relied on the judgment in Bengali immunity case, whereas it was held that when Article 141 lays down that the law declared by this court shall be binding on all courts within the territory of India, please note this, my lords, it quite obviously refers to courts other than this court, and that the court would normally follow past precedents laid down in that judgment. In fact, overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. Your lordships can say, if persuaded, that Tamil Nadu judgment is not laying down the correct law. It's not your lordship's appellate power, is your lordship's inherent jurisdiction. Inherent power. This inherent power can be exercised as long as previous decree vis-a-vis in a list inter partes is not affected. It is the attempt to overrun the decision of a previous case that is problematic, which is why the court observed as under, my lord. Please now come to 45, para 45, lords, where the court distinguishes decision and the point of law decided in that decision. My lord, page 817, my lord, and two paras, my lord, I am done. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri.
Paragraph?
Para 45. 8179. And two very interesting paras, my lord, which generally go unnoticed, my lord, but I must place for your lordship's consideration. Para 45. My lord, dear argument was that one of the questions referred by the Honorable President is whether this judgment is right or wrong. Can you do that? In answer to that, my lord, this court, my lord, speaking in this reference judgment, says this. 45. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri 2, which according to him prohibits this court from overruling a view expressed by its previously under Article 143(1). We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Now, please, the Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these two situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draw a difference between the two by using the word when further this court overrules the view of law after discussing the decision. Then 47. Therefore, the reference in para 85 of Kaveri to decision and view of law must be severed from each other. The learned judge observes that in case of a decision, the appellate structure is exhausted after the pronouncement of the Supreme Court. Therefore, the only option left to the parties is to review, etc. Now, please see Classitem D. However, this is important and I place respectful emphasis. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced in the course of reaching the decision. Justice Sawant clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power when he says, that is again in a reference. Justice Sawant is deciding whether 143 would cover overruling a judgment and says, which is affirmed in 2G, that yes, we can overrule the question of law decided in the judgment. Now kindly see two paragraphs and they are very interesting paragraphs. Para 61 and 62. Because this, it appears that has been a consistent tendency of opposing reference of the Honorable President. And so far in our history of this constitutional democracy, there are only 15 references made by the Honorable President on individual bill or individual facts, etc. Please see 61. From the aforesaid, it is, your lordships have 8187. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modifications may be stated as one of the modes or methods of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one cannot be oblivious of the fact, etc. But see 62. It is of some interest to note that almost every reference filed under Article 143(1) has witnessed challenge as to its maintainability on one ground or the other, but all the same, references have been answered except in Muhammad Ismail Faruqi, that Babri Masjid case, which was returned unanswered, mainly on the ground that the reference did not serve a constitutional purpose. Basically, the court said, we are not experts on the subject of adjudication which the President has referred. Kindly, my lord, and your lordships are aware of the fact that the highest head of the executive is seeking your lordship's guidance that there are judgments of 5 judges, 2 judges, 3 judges, 7 judges, and it has created a constitutional functional problem for us. How would the President govern?
You can't expect the Supreme the conflict of judgments.
I'm not.
In an opinion.
Functionality, what would be the contours of Article 200? Am I bound by the 3 months deadline? Am I bound to record reasons when the Constitution doesn't provide? Am I bound to intimate everybody? And is it permissible for the court to say that every state will come to the court? Lord, we are not, my lord, we will be addressing this on the merits of the case. But, my lord, there has to be a difference and deference when, my lord, the court is dealing with constitutional functionaries, which is a part of separation of powers, my lords. And therefore, my lord, one of the questions raised is, could the bench of the strength which decided the question without setting aside their judgment, my lord, your lordships, my lord, is requested to opine, have decided this question in light of the constitutional mandate under Article 145(3), and despite a request being made that please refer to the larger bench. This is one of the questions being answered. This, my lord, question is a sui generis question in itself, my lord, as compared to other questions. My lord, therefore, my lord, we'll address your lordships on merits, and my lord, we'll satisfy your lordships about we will assist the court, my lord. This is not a list to be decided.
Both
Yes.
sides probably are very clear that we are in advisory jurisdiction.
Yes.
We are not sitting here as appellate forum.
My lord, sir.
You are also saying, they are also
Yes, yes.
ending that, so it's very clear.
Yes.
You are absolutely right, 143(1), question of law has a reason or may arise in future, we will answer that.
Correct.
Whether a question of law first has a reason, and if a reason, how it is to answer, right?
What are the contours, etc.? Yes.
That process, the court can render an opinion that a judgment does not lay down the correct statement of law.
Your
Or
lordship.
judgment lay down a correct statement of law. But that will also not technically amount to overruling the judgment. It will be a different opinion. For overruling, you might be required to refer.
My lord, the 2G judgment, my lord, if I take your lordships.
Maybe
My lord, 2G judgment and my lord, in Kerala bill, I think 7-judge bench of this court, my lord, has said that in a reference, answering the reference on a question of law, on a proposition of law, your lordships can even overrule the judgment.
I mean, that part can be checked. Otherwise,
Lord, para-
yes, we can always declare
Lord,
that.
para 56,
does not lay down-
my lord, immediate, para 56 of 2G. 50. Para 50 and 56. My lord, just to answer your lordship's question. Kindly, my lord, come to para 50 and 56. My lord.
Yes.
Lord, 8182. Para 50, my lord, 8182, your lordship said, my lord, which relies upon special courts bill. That's 7-judge, my lord, bench judgment.
Which volume is that?
Para 5, my lord, it starts with finally. I'm sorry, it is volume
50.
5.21, page 8182. Directly answering, my lord, what my lords, my lord, were pleased to put to me. Does your lordships get, my lord?
Yes.
My lord, Justice Vikramnath gets 50. But this is 2G.
I get what it first, huh?
Well, your lordships are always, my lord, more techno-savvy than the rest of us, my lords. Finally, a 7-judge bench of this court has clearly held that this court, under Article 131, 143(1), does have the power to overrule a previous view delivered by it. Chief Justice Chandrachud in Special Courts Bill.
You can be overruled, but not a decision.
Correct.
That's right.
That's what,
But
Clarify.
please read, my lord, what the 7 judges say. We are inclined to the view that though it is always open to the court to re-examine the question already decided by it and to overrule, if necessary, the view earlier taken by it, insofar as all other courts in the territory of India are concerned, they ought to be bound by the view expressed by this court, even in the exercise of its advisory jurisdiction under Article 143(1). Then, my lord, para 56, my lord, kindly have a look at para 8185, my lord, para 56.
one.
Even legislatively, if we overrule a judgment.
You can just say in case of saying this is the VP privileges case. It's overruled 6 judges in exemption issue. The fundamental rights and national privileges.
I don't consider they are article. It's a wrong law. My lord, I'm not reading it. My lord, Keshav Singh judgment, your lordships are aware, my lord, that Uttar Pradesh, the dispute between, my lord, the assembly and the, my lord, there was some privilege issue where, my lord, the reference was made. And in that, my lord, the honorable court overruled the view taken that this judgment does not lay down correct law. Well, otherwise, my lord,
Affirming or overruling a view definitely is permissible.
Certainly.
Otherwise, how will exercise 143?
140.
Can't exercise that. That is understandable.
Even the legislative process also.
Pardon?
An act cannot take away the mandamus, the chief was saying. Same independence of judiciary.
Pardon?
No, no.
Oh, that's a separate. Yes, yes, my lord, we will be. My lords have taken the view, my lords. My lords in that extension of
Yes,
certainty, my lord.
believing justice not and
No, we are not, fortunately, my lord, faced with that situation. We are possibly, my lord, if I may say so, faced with a converse situation.
Just one submission for your lordship's kind consideration.
May I be
My
heard?
lord, which is,
Only,
which-
Mr. Salve wanted, my lord,
Yes.
5 minutes.
No, I want
Can I just-
5 minutes by the clock.
just Mr. Let Mr. Kaul finish after finish.
my lords, 2G, as fell from my lords, emphasizes the distinction between decision and a view of law, and a review and a reference, and goes on to say that a review or a decision deals with the lis inter partes. A view of law is what is not eternal, malleable, and is subject to overruling, clarification, and modification. And that is why, my lords, in para 101 of the 7 judges' judgment, which is relied on in para 50 of the 2G judgment, they say we can overrule. And overrule, as felt from my lords, is not in exercise of either appellate jurisdiction or appellate jurisdiction being vested by a presidential reference, which can never be done. It is an exercise of the inherent power conferred on the Supreme Court to look into it and overrule it. And that is the reason why it was done, and 2G referred to it, refers to Kaveri. In fact, my lords, Kaveri, subject to correction, does not deal with the 7 judges' decision in the manner it ought to have, which is para 101, which talked about that 143(1), you can exercise the jurisdiction to overrule. And that ratio can be clarified. So the fundamental error is to say that you're vesting an appellate jurisdiction in this court while exercising its jurisdiction, while answering an asked for by the president. It is not an appellate jurisdiction that your lordships are exercising in the matter. And my lords, as far as a reference is concerned under 143, the president's opinion and satisfaction has not only been held to be non-justiciable, has been the final arbiter as far as the issue is concerned of whether a question arises. Is that question of such public importance that the opinion of the Supreme Court is needed on it? That is where, that is the decision. Then whether your lordship choose
That's
to,
not be correct, Mr. Cole.
yes,
143(1) talks of may, and
Yes.
that's why 143 to talk of shall.
yes,
In shall, we are bound. We
Yes.
have to answer it because that will referable to 131. In 143(1), first we will determine that is there a constitutional question of law has arisen or is likely to arise, which requires our opinion.
my lords, your lordships are
It's
absolutely.
not something 143(1) that a reference comes and we are.
No, my lords, I didn't say that. My lords, I did not say that at all. Your lordships are absolutely right. All that I said for 143(1) was the satisfaction of the president. Whether your lordships answers it or not, because your lordships has laid down guidelines to say that it could be a case where your lordships feels it's purely political in nature, ought not to be answered. Or such questions of fact or expertise are involved, we can't answer that. But all that I'm saying is that satisfaction of the president sending it, whether your lordships answers it or not, is a separate issue.
Once the court is satisfied.
Yes, absolute. That's all that I'm saying, Malas. There is no difference on that at all. But all that I'm saying is it cannot be treated today as if your lordships are deciding lis inter se. Your lordships will only be deciding pure questions and views of law, which your lordships in exercise of your lordships jurisdiction under 143 are fully entitled. I'm very grateful.
Appealing for whom?
My lord, for the state of Madhya Pradesh. Very grateful. my lord.
Yes.
My lord,
so I'm-
just 3 quick points, my lord. Your lordships have seen all the judgments. I don't propose to read any of them. Your lordships would have noticed this is not a jurisdictional bar. It is a self-imposed discipline. First of all, my lord, it's not a jurisdictional bar. The way, because we use the word maintainability rather loosely. Maintainability normally is a jurisdictional bar. My lord, the very doctrine of precedent is a self-imposed limitation. Let's keep certain first principles clearly in mind. My lord. Under Article 141, your lordship's judgment bind every court in India. They don't bind the Supreme Court. That's why your lordships have a right to overrule past precedents. These are all self-imposed limitations, and for very good reason. So, my lord, it's not a jurisdictional bar. And Dr. Singhvi threw in 3 different expressions. First, he said stare decisis. Stare decisis, my lord, has never stood in the way of a court considering and turning around a erroneous view. Res judicata is quite another matter. In the facts of a case, a decree will continue to bind until that decree is set aside in a manner known to law. And that principle is not being affected. So, my lord, all these notions, and the third is, my lord, what is really happening today, with great respect, is you're putting the cart, this challenge in this manner puts the cart before the horse. Your lordships are not even engaged with the questions. When your lordships engage with each of the questions, your lordships will then say, this is covered, this is not covered. For example, if we are right that on some of the issues, this honorable court has, and it happens many times in constitutional issues, in some of the issues, this honorable court has spoken with different voices. In one context, the court has said something, in another context, the court has said something else. The judgments need to be read, they need to be reconciled. And at the end of the day, your lordship may answer this question saying, this is covered by this judgment and there's nothing more for us to say. But that's not maintainability. That is answering the question saying this is answered in the light of the following judgment. So, my lord, I think your lordship should, without any more waste of time, my lord, engage with the questions and consider which of them your lordships want to answer and how your lordships want to
You
answer.
also contributed in that waste of time to some extent.
I'm sorry, my lord.
You also contributed in that waste of time. to some extent.
Absolutely, my lord. All of us have generously contributed to this.
Not generously. Not as generously as Dr. Singhi and.
Yes. I've been the most miserly in that, my lord. I have nothing more to add.
Yes, you.
Normally you don't require mic, but you can have it.
It is only an issue of overruling an earlier view, number one. Number two, or making it authoritative without any doubt. Two modes are constitutionally and legitimately provided. One, a reference by a bench of this honorable court to a larger bench to provide consistency and authority without any ambiguity, much less than conflict. Number two, if Lord exercise appears that there is no consistency in the conflicting views, requiring reconciliation, clarification, or modification, it is entirely permissible for a second method for the Honorable President to resort to 143, and more so if it raises a ambiguity on the application of constitutional provision. Therefore, it is entirely maintained.
Thank you.
Grateful.
You are beginning.
Yes, I
Opening note.
propose to make some broad submissions. Your lordships will
Attorney, your timelines appear to be far exceeding what is.
No, I don't think I will exceed the time.
No, have you seen the timeline?
Maybe we will be within the timeline.
You will have to revisit it because otherwise.
No, no.
We'll conclude ours internally within 4 days allotted.
Very comfortably.
You will have to revisit.
Very comfortable.
The timelines given to us are, I think they will spread over 2 weeks.
I will not breeze the timeline.
We can always overrule, my lord, this time schedule. And
Your lordships
on the lighter.
we have my written submission paper book. It's volume 1.2, the soft copies. But I also handed over a hard copy to your lordship. So you are starting with the main issue. There's 2-3 issues. Then I line it out. I have certain be better to give an overview. I give the history. We will be doing the history. We will give the history. Going this way. I'm not going to overthrow the overline. You will not come later. Comes later and we come later. I suppose so. 1 hour 30. Your Lordship, please. I set out about broadly 5 propositions in the written submission. One, of course, relates to the maintainability. I don't propose to deal with that question.
That you already addressed.
That's right. But before I do that, the series of questions that have been framed and placed before your Lordship for consideration have a certain internal intrinsic connection. And we are looking at 2 important provisions of the Constitution, Articles 200 and 201, and which, in the company of other provisions of the Constitution, occupies a special scheme in the distribution of powers between the governor, the president, and the legislature. So it's like a fulcrum where the governor and the president plays an important role as guardians of the legislative integrity and constitutional integrity. And the legislative role assigned to the president and the governor is now been noticed, endorsed, and acknowledged by several divisions of the court. Of course, this legislative role is not equivalent to a plenary powers of a legislature, but decidedly the constitution makers could have thought, why we need Article 200 and 201 at all? If in democracy only the legislature has the final say, and why do you have any roadblocks? Why do you have somebody to be a supervisor, a night watchman? So if 200 and 201 continue part of the constitutional scheme, there has to be some important assigned to 200 and 201. If in the course for any political other expedient reasons, and an argument is canvassed before the court that please look at 200 and 201 in this particular way, because that's going to be democratic. So I suppose the court will look at the concept of democracy, keeping in mind the institutional relevance of Articles 200 and 201. So as we go further, we'll say that what the Tamil Nadu judgment has done, and in the context of other judgments, there are a number of judgments will look at Articles 200 and 201. How the scheme will work, and what will the governor do, what will the president do, how do we read and interpret Articles 200 and 201, so on and so forth. We will in due course of time take a lot of those judgments. But the debates on the discharge of functions between the governor, the president and the governor and the legislative wings of the state, this functional assignment, I think, is something very important. But that's the running, the blood which infuses the life into Articles 200 and 201. So whatever issue that may arise, in the discharge of functions in the Articles 200 and 201, in the course of exchange of views between the governor and the president on the legislative assemblies, and there are some issues, whatever the issues that may be, and if they need to be resolved, how will you resolve them? So we find in the Tamil Nadu judgment that the court says, we will resolve those issues. We will provide answers to all those issues. So in the end, what has really happened is, I'll also place your lordship in consideration, read the text of Articles 200 and 201 as they existed in the constitutional text, and read them now as has been done by the pen and paper in the Tamil Nadu judgment. You will find the court has entered into a legislative exercise and nothing but a simple legislative exercise. Therefore, whatever issue that arise between, if there is issues arise between the governor, the president, and the legislature, then the parliament will certainly look into it. You have to address the parliament to say, look at the importance of the issues. The governor and the president cannot probably abdicate their highest responsibilities in ensuring that legislative compliance, the constitutional compliance of a law is ensured. Therefore, that's how I think the court would have probably looked at it. As I said, a series of judgments where 200 and 200 have been dealt with by the court. 7 judges, 5 judges, 3 judges, etc. They all kept it in mind. That issue has all been kept in mind. Therefore, the court will probably, in my understanding, will reach several principles in delineating the scheme of Articles 200 and 201, keeping in mind the basic structure of the Constitution. To say the basic structure is only informed by a democratic principle which is confined to the legislature, I don't think that will be the more advisable way of looking at the basic structure doctrine. Therefore, 200 and 201, I say, is also a part of the basic structure, where the president and the governor occupy an important functional role in ensuring that if there is a non-constitutional compliance with a bill, the president and the governor will say stop. To do that stopping, I think if you call it, give some other name and then say, let me dilute the level of responsibilities of the governor and the president. That's where the Tamil Nadu judgment has ended. We'll place more submissions when you come to the question. So the questions that have been framed have been kept into mind. The series of judgments that have dealt with Article 200 and 201, and that's why you lordship asked me a question about why are you talking about 145.3? Why are you talking about this particular question, etc. I'll presently come to that. So in the tune with the range of opinions in Article 143, I say it's open to the Supreme Court while answering a reference to look into and consider any of his previous judgments and to find out the answer we were trying to canvass that what is the correct state of law in Articles 200 and 201, which the president is concerned. The Tamil Nadu judgment, in deviation and departure from many other judgments, says if there is a dispute regarding, I'll presently play that paragraph of the judgment, if the dispute regarding whether the governor could reserve a bill to the consideration of the president, and the president has any issues on that, it should be as a matter of prudence, the president should come to the Supreme Court and seek his opinion. So it becomes a mandate for the president to always seek an opinion from under 143 whenever there's a doubt about whether the governor has actually given a consent could be given or not, materials are available or not. So we enter into wide conundrum of issues in this case. So that is why it was found expedient to have this reference made before your lordships. Now in my written submissions, let me invite your lordships, volume 1.2, page 410. Proposition number 1 relates to what we have already advanced. You get to proposition number 2, also in a way deals with that question, but I would like to read that, page 411. So it is related to maintainability, etc. Then proposition number 3, your lordship.
I do not know. On one and two, I have so much justification of I won't permit me to. That's all. That's all.
And then proposition number 3 at page 411, the doctrine of separation of powers injuncts the court from doing what the legislature alone can do. It's well known, it's part of our jurisprudence. The principle that the court declares the law by interpretation cannot be extended to essential lawmaking. As will be submitted below, the Tamil Nadu judgment has substantially rewritten Articles 200 and 201 of the Constitution, whether affecting such textual amendments of the Constitution will not be in opposition to the separation of powers principle is a matter of great public importance and for constitutional integrity.
Your written note.
Hey, written submission.
Submitted today.
It's volume 1.
पता नहीं, बड़ा वाला है। ये वाला। ये वाला।
I'm so sorry.
Yes.
You can just formulate your point because this in any case will be reading through.
Yeah, these are 5 propositions to begin with, to open the debate.
So one of the main proposition appears to be this court has encroached upon the legislative powers of the parliament or has sought to rewrite the constitution
Right.
or amended the constitution,
Yes.
which is not permissible for this court. That appears to be your main submission.
That's one important submission. So how the judgment now, as I said, Article 200 before and after the judgment. So if you look at it, it will be it's so plainly visible that it is a matter of textual amendment of the Constitution. So we'll presently come to Article 145 to our 3 argument. So even in the guise of interpretation, laying down guidelines, Vishaka, etc., so can the court go to the extent of saying that I will myself, as I say, take a pen and paper and rewrite the Constitution? And at page 414, proposition, I'm skipping proposition number 4. Because there was in the Kerala a written submission that an objection Mr. Venugopal did not press. There was an objection that the presidential reference does not advert to the Tamil Nadu judgment, and there's something like you're suppressing a judgment from the court. And since that has not been addressed, wisely so, I don't propose to go into proposition number 4. But I understand that Article 143, as I said earlier, is not does not admit of questions such as pleading, etc. Now, proposition number 5 at page 414, and that's also been addressed earlier when what we are actually seeking this court to do under Article 143, that the state of law or the view of law, etc. If your lords will permit me to take straight away to in this written submissions is in 4 parts at page 415. Page 415. Part 1 deals with the special features of Article 143. I'll keep coming back to it as and when necessary. I don't propose to read it because you understood that there is a significant difference between 143 and other jurisdictions of the court. And what will be ordinarily attributable to jurisdiction, the exercise of jurisdiction, etc., does not relate to Article 143. Then this part 2 deals with the presidential reference maintainable. We've asked this question. Then part 3, the text of the constitutional post Tamil Nadu judgment. If your lordship permit me to read that. Before that, may I address your lordships on the question posed to me about 145.3. Situation. 1461, that's the thing. Question number 12, like page 461. Will not kindly turn to page 61 of this volume. 61. 461.
6. From 416 we go to 461. That's part 4.
Because what we have, that's right, part 4. So what we have done is, with reference to each one of the questions, we'll be having a division of labor, and few questions will be certainly answered by me, and others will be dealt with and solicitor. So since part 4 is about question number, I begin with question number 12.
Yes.
This is how the question reads. In view of the proviso to Article 145.3, is it mandatory for any bench of the Supreme Court to first decide whether the matter involves a substantial question of constitutional interpretation and refer it to a bench of at least 5 judges? If I look at the text of Article 145.3, rule. 145.1 reads like.
If your contention that in every matter, the court should first go into the question as to whether it is mandatory to refer to the bail. If a bail matter comes, they will first decide as to whether it has to be referred to.
No, that's not going to be our submission. It's constitutional
The
interpretation.
question should have been involving an interpretation, involving any of the articles of the Constitution.
You kindly read 143 for a minute.
No,
The
the
minimum
question is
number
in
of
view of the
judges.
proviso to Article 145.3.
The minimum
Mandatory
number
for
of-
any bench of the Supreme Court to first decide whether the matter involves a substantial question of constitutional interpretation and refer it to bench of at least 5 days. If you go through this exercise on Mondays and Fridays, we'll have to sit till 12 o'clock in the night.
Your lordships have answered, dealt with this in various judgments. So whether it will be reduced to that minimum, whether it will be reduced to that minimum or it stands at a higher level. Therefore, at one level, one will say every question that comes to the Honorable Court will may involve an interpretation of a provision of a constitution, application of a provision of a constitution. We're not saying that.
Which involve interpretation should go to.
One 145.3 is very clear in its prescription. There's a minimum number of judges who are to sit for the purpose of deciding.
But what is this? Whenever
involving
any question involving an interpretation of the provisions of the
a
Constitution.
substantial question of law as to the interpretation of the Constitution. Your lordships have on many occasions dealt with this provision and have given certain opinions on how do we deal with them. I look at them.
It's a broad contour. It is not a mandatory or anything. It shall be by 5. That doesn't mean that mandatorily every time the court, the moment a constitutional issue is raised, we will have to refer it. But in any event, Why should we answer this question at all?
Let me tell you that's why you're asking this question. Before the Tamil Nadu bench and even before the Punjab was, it was sought to be persevered before the court that here you have a bench of 5 or 7 judges who looked at Article 200 and 201. And if you have to disagree with them, then ordinarily the practice of the court is that you refer it to a larger bench and goes to a bench of 5 or 7 judges, the case may be. So we have those cases even in Inamdar and Islamia. So a larger bench is now sought to be explained by a bench of 5 or 7 judges. Even when explanation takes place, you have a bench of not a bench of 2 judges.
The judgment of 9 judges is explained by 7.
Yeah, let me try to open what I've heard. So we are trying to point out that if there is an interpretation of such constitutional importance, which is not a mere daily appearance of matters in the court where 14 and 21 are involved. We're not talking about those categories of cases. So in those categories of cases where matters of constitutional importance, for the working of the Constitution, working of the institutions of the Constitution, under the Constitution, the integrity of the Constitution, so on and so forth. Certainly 145.3 imposes a mandate. This mandate can be certainly exercised after the court goes through a particular judgment and whether there is a need for referring it or not. That will be an exercise at a different level. But if the court were to say that notwithstanding issues of constitutional interpretation, which are of such public importance, and notwithstanding the fact there are larger bench views on this question, then a lesser number of 2 judges can decide it and answer it, I think is directly in conflict with 145.3. The court exercises both original and appellate jurisdiction. Cases come from various high courts on the interpretation or the application of state legislation, central legislations, regulations, rules, orders, so on and so forth. And therefore, in that context, when the court finds that important questions of substantial questions of the interpretation of the Constitution involved, if the matter can be disposed of on a lesser level, on a facts, etc., then certainly 145.3 may not arise. But if I take interpret the provision of a constitution, which will have implications, as I said, for the functioning under the constitution of the institutions of the constitution. So therefore, the daily stuff where this court deals with the application of 14 or 21 will be a different canvas altogether. We are talking of those very special class of cases. And articles 200 fall into those very special class of cases.
What's your proposition that the moment a question of law relating to interpretation of the Constitution is raised in a ground in an SLP or submitted, every such matter has to be referred to a CD?
The court will address, is the field already occupied by any conclusive authority? I'll presently praise those decisions where these have come up for consideration. The court will address that question. If there is a conclusive authority or authoritative opinion, 2G talks about authoritative opinion. So it is not any opinion. Therefore, a conclusive authority or authoritative opinion, is there such a conclusive authority? The court will address that question first. If there is no conclusive authority, but while even looking at the conclusiveness of authority, the court finds there are conflict of views, 2, 3, 5, etc. Therefore, then the court will certainly say, if this is a matter of such public importance, constitutional interpretation, I think I am duty bound to refer to a constitutional bench. It's a high responsibility. The court interprets the Constitution, substantial questions. So it's a high responsibility. Therefore, when the court enters, the moment the court enters into a disagreement on a field which is either occupied by a number of judgments, 5, 7, 2, etc. Should the court say, no, I will probably take the mandate on myself and let me bear the mantle to answer a question? The court will be very slow. My submission, the court will be very slow before it finally takes a view that I need not refer the matter to a larger bench.
And even you should not ask that in an advisory jurisdiction.
No,
You should aim for a determination in a regular.
no, why
That will be binding on other benches, saying that we have to do it. But then you are asking as a question, as an opinion. Opinions also could be polyvocal.
Let me try to proceed further, and the Lordship probably heard why this question is being asked. Firstly, the question being asked because we have the instance of a Tamil Nadu judgment where, in breach of 145.3, the court has proceeded to answer some of the questions. So it becomes important for the president to understand and for the government also to know in what circumstances a 145.3 can be kept aside or maybe ignored, disregarded, and departed from. Therefore, this question has been asked. It's important for every functionary, government, legislatures know whether 145.3 is important or not. Is it mandatory or not?
Yes, Mr. Attorney, please.
I was reading at 461, paragraph 43. Lordships may permit me to refer to Balasaheb Patil and what this court had said in that.
Karnataka.
In any case, we feel there is a requirement to provide a preliminary analysis with respect to the interpretation of this provision. In this context, we need to keep in mind two important phrases occurring in Article 145.3 of the Constitution, which are substantial questions of law and interpretation of the Constitution. By reading of the aforesaid provisions, two conditions can be culled out before a reference is made. The court is satisfied that the case involves substantial question of law to the interpretation of the Constitution, the determination of which is necessary for the disposal of this case. So that's the second stage. If you don't pass the second stage, then there is a breach of 145.3. Then next paragraph. Any question of law of general importance arising incidentally or any ancillary question of law having no significance to the final outcome cannot be considered as a substantial question of law. The existence of substantial question of law does not weigh on the stakes involved in the case. Rather, it depends on the impact of the question of law will have on the final determination. If the questions having a determining effect on the final outcome have already been decided by a conclusive authority, mark this word, conclusive authority, then such questions cannot be called as substantial questions of law. I mean, stopping it for a minute. If such a question has been decided by several conclusive authorities, bench of 5, 3, or 2, then would it not be, I think, prudent for the court hearing a matter involving the same question to say if there are the larger benches and if there is that's a conclusive authority, or if I doubt even about that conclusive authority, then I need a conclusive authority. The court needs to present a conclusive authority in order that the questions are not repeatedly brought before the court. So you need to answer them by way of a conclusion so that the jurisprudence is settled and the authorities and Article 141, precedent, etc., all that will take their effect. Therefore, let me read further. In any case, no substantial question of law exists in the present matter, which needs to refer to a larger event, the cardinal need to achieve a judicial balance, etc. Then, next paragraph. Furthermore, this court in K.S. Puttaswamy has noted that when a substantial question as to the interpretation of the Constitution arises, it is this court and this court alone under Article 145.3 that is to decide what is the interpretation of the Constitution shall be. And for this purpose, the Constitution enters its charge the minimum of 5 judges of the court. Reference can be usefully made on the following judgments, and so on and so. On the question of the interpretation of Article 200 and 201, I just give a CA to those judgments so that why we're talking about it. The following judgments are stated, the law as follows. When in Samsher Singh, this court has recognized that the governor is required to exercise his discretion while discharging certain constitutional functions, including inter alia, those envisaged under Article 356 and 200 of the Constitution. Then, next page, in Valluri Basavaya Chowdhury, the court held that save in the case of a money bill, the governor retained the discretion to withhold assent to a bill presented before him. In Ramesha Prasad, this court observed that the governor discharges the dual responsibility, being accountable to both the union and to the state in the exercise of its constitutional functions. In Navem Revia, this court recognized that the governor is vested with discretion in the exercise of powers under Article 200 of the Constitution. In BK Pavitra, this court held that the Constitution confers a discretion upon the governor with respect to the reservation of bills by the consideration of the president. It is observed that the discretion is vested in the governor to adopt one of the course of action set out in the substantive part of Article 200. The court further affirmed that the governor is entrusted with authority to reserve a bill presented for his assent by the consideration of the president, and such reservation may validly be exercised even contrary to the aid and advice tendered by the Council of Ministers. The Tamil Nadu judgment proceeds to say the governor in all his functions under 200 is to be to go by the aid and advice of the Council of Ministers, is bound by the aid and advice of the Council of Ministers. I ask myself the question, if a bill presented to the governor is not constitutionally compliant, or what he thinks is not constitutionally compliant, am I required to go seek the aid and advice of the Council of Ministers, except we have a consultation? These are all informal things, but to say that I am bound by an advice, if the law is already unconstitutional, not constitutionally compliant. So where is the question of saying for giving my assent and withholding assent, I should seek the aid and advice of the Council of Ministers? Therefore, that's how in Pavitra, the court, it's a balance. It will be brought on record, paragraph 46 later, that in the light of the views expressed by the benches of the Honorable Court of varying strict on the scheme of Articles 200 and 201, it was requested before the bench hearing the case in Tamil Nadu Supra, the proper that the matter may be referred to a larger bench as mandated by Article 145(3). This submission is recorded in so-and-so. As to harmonize a little later, the submission also advanced in the course of making oral submission. However, the Honorable Court proceeded to render a judgment adopting the course of explaining and distinguishing the judgments in question. It is submitted that in such matters of constitutional interpretation, even the exercise of explaining or distinguishing should be undertaken by a larger bench. I think that will be the real essence of 145(3), because the matters of the moment come before the court. So you want to explain, but the larger benches to be explained. Would it not be proper that I follow a 145(3) route, having regard to the significance of what the court proposes to do and the impact on, as I said, constitutional functions? Next paragraph. It is further submitted that the breach of this mandate is akin to the act of court principle, namely, that an act of court will do no wrong. In other words, the act of court principle will include violation of principles of natural justice, not acting in conformity with mandatory statutory provision, as in the case of A.R. Antule, and in all those situations, and more importantly, in the context of a constitutional mandate, such as Article 145(3), a judgment so rendered cannot be said to express the correct state of law and shall be open to correction. That's why we talk about conclusive authority. The correct state of law will follow if there's a conclusive authority. Next, it is submitted that in the breach of Article 145(3), in the manner it has occurred in the Tamil Nadu judgment, is a matter of constitutional concern. Given various issues in the reopening of such a judgment, through the process of review, etc., it has become important to raise this concern, and such a concern deserves utmost consideration by the Honorable Court. There can be no two views on the question that in the absence of an authoritative pronouncement, paragraph 63 of the Natural Resources Allocation Judgment, or a conclusive authority on the subject in question, Shriman Balasaheb Patel, it will not only be prudent, but also proper for the court to go through the mandate of Article 145(3).
Yes. What is the next now?
Where is it? 200 and 201, where have you placed it? Before and after. Hmm? Okay.
Why doesn't matter?
451. Pages in 451 to 456. There are certain submissions. Before I read them, kindly turn to page 456.
Extra 201 and 21.
456 within that sub
So you want to,
Article 200, within the box you'll find Article.
As it stood before and as it stood now.
As it stood before is what I'm going to read now.
as
And
it's
later,
before and
yeah,
how it has been read by the court.
we have
Now
picked
how
up, that's right. We have picked up whatever the court has said about 200 and then added them as part of the way you read 200 now after the judgment. If there is any error in that, of course, you're open to correction. Now let's read Article 200 as it stood before. When a bill has been passed by the legislative
Your
assembly
question
of
number?
the state, 456. Your Lordship, please.
This is a part of your written submission or written submission to a particular question.
No.
You have divided your questions amongst yourself.
I know, I have dealt with 145.
Part of the question.
I'm now dealing with 200 and 201. How, that's right. How under the guise of interpretation,
This is independent of the question.
Learned Attorney General Melody is addressing your lordships as the learned Attorney General. I'll be assisting your lordships for
As a constable for Union of India.
for the Union of India. But we have different nuances. We will-
Because that, in the beginning, the learned attorney stated that we have divided.
Some questions, yes.
Yeah, we are,
Yes,
we have.
there'll be no overlapping, but
Yes.
of course, the
There will
bound
be
to
no
be,
duplication
bound to be
of-
some submissions which may have some element of overlapping that cannot be avoided in a matter like this. So it's important for us to read Article 200 as it's the text of the Constitution. So when a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has been passed by both the houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill. Lord Narasimha, got that page?
456.
I thought just Narasimha. Either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president, provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message. And when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and the bill is passed again by the House or Houses, with or without amendment, and presented to the governor for assent, the governor shall not withhold assent therefrom. I'll make my little comment on this little later. Provided further that the governor shall not assent to, but shall reserve for the consideration of the president any bill which in the opinion of the governor would become law, so derogates from the powers of the High Court as to endanger the position with the court is with constitution designed to fill. Now, next page, we turn to how it now looks after the judgment. The portions marked red are introductions by the court. When a bill has been passed by the Legislative Assembly of a state, or in the case of so-and-so, etc., the governor shall forthwith, and in any event not later than a month from when it is presented, either on the aid and advice of the Council of Ministers or otherwise, on ground that a bill is of a description as provided in the second proviso here and below, or that a bill is of a nature covered by Article so-and-so, etc., where the assent of the President is a condition precedent before the bill can take effect as law, or on the ground that a bill is of a nature that if allowed to take effect, then undermine the Constitution by placing the fundamental principle of representative democracy in peril within a period of 3 months from the presentation of the bill, declare either that he assent to the bill or that, if it's not a money bill, regardless of whether it is introduced in terms of Article 207, he withholds assent therefrom, or that he reserves the bill for the consideration of the President. Substantial insertion in the text of the Constitution. Provided that the governor may, as soon as possible after the presentation to him of the bill for assent, if he withholds assent, contrary to the aid and advice of the Council of Ministers, on grounds that the bill is of a nature that if allowed to take effect, it would undermine the Constitution by placing the fundamental principles of a representative democracy in peril. Then return the bill if it's not a money bill, etc. And little later it says, the House or Houses shall have the option to reconsider the bill accordingly. And if it is so reconsidered, the bill is passed again by the House or Houses without the amendment presented to the governor for assent, the governor shall not withhold assent therefrom. So you see a scene entirely different from what the constitution makers envisage to ensure that there is a fine balance between what the governor will do or the president will do, and when a bill which is of non-constitutional compliance is brought to his notice. So I will certainly look into certain other questions about whether the aid and advice of the Council of Ministers will bind when the bill is so unconstitutional. And then if the governor is to go and seek his advice and say, should I abide by your wisdom? The court says, yes, you are bound by the aid and advice of the Council of Ministers, and because you have no discretion. So all that flows by reason of the textual amendment of Article 200. Now kindly turn further at page 458. Provided further that in the first instance itself, and not in a situation where a bill is presented to the governor, again under the above proviso, the governor shall not assent to, etc. That's how it goes. We introduce this. That's a third thing now. Provided further, where the governor proposes to declare the bill is reserved for the consideration of the President, and whereas a declaration is contrary to the aid and advice received from the Council of Ministers on any other grounds set out in the first proviso above, such declaration ought to be made not later than 3 months from when the bill is presented, except when such presentation is in accordance with the first proviso above. Now, how do I understand the way the court has construed Article 200 and say, I read all of them into 200. Now, the governor will have to now follow this mandate, I think. The governor will receive the advice from within the scope of all these insertions, the textual amendments, the judgment is affected. See further, therefore, again, Article 201. 201 is a very simple provision. Bills reserved for consideration.
What is the last proviso?
No, it's all part, I picked up from the judgment and added them here.
According to the last proviso is also added in the judgment.
Added, yes. And when I say it's added, this is how the governor will be bound by it.
So the third proviso.
The governor will look at it, the president will look at it. Am I to follow this procedure? Therefore, it gets impregnated into Article 200. Can the governor say, so I will not look at all because only a judgment? He cannot say so. 201. When a bill is reserved by the governor for the consideration of the president shall declare either that he assent to the bill or that he withhold the assent therefrom. Provided that a bill is not a money bill, the president may direct the governor to return the bill to the House, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the first proviso to Article 200, And when a bill is so returned, the House or Houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and is again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. Now, the elegance and the simplicity in Article 201. Now, see after the judgment. When a bill is reserved by the governor for the consideration of the President shall forthwith, and in any event not later than 3 months from when the reference is received, which time may be exceeded for reasons to be recorded in writing, declare either that he assents to the bill or that he withholds assent therefrom, recording reasons therefore, and communicating such reasons to the House or Houses of the state in terms of the proviso below. Provided that the assent is withheld, where the bill is not a money bill, the President shall direct the governor to return the bill to the House, or the case may be the House of the legislature of the state together with such message, as is mentioned in the first proviso to Article 200, which message shall include the reasons specified in this article, and when a bill is so returned, the House or Houses shall reconsider accordingly within a period of 6 months from the date of receipt of the message, and is again passed with the House or House with or without amendment. It shall be presented again to the President for consideration, who shall ordinarily not refuse assent thereto. You bind the hands of the President here. The Article 201 set does not talk about binding the President, giving or not withholding an assent. It's all certainly the President will exercise the highest level of consideration of a bill. If assent is withheld, she or he will withhold the assent. Provided all this further. Provided further that the President shall not use the above mechanism of withholding assent and sending a message to the state legislature more than once in the ordinary course of action. I thought the court has probably entered into a regulation-making power here. Provided further that when a bill is presented again to the President for his consideration, the President shall withhold assent again, record clear and sufficiently detailed reason therefore. We are looking at the President as an ordinary statutory authority. The recording of reasons I'll come to a little later, while may be important for the legislature and the transaction of understanding between the governor, the President, and the Parliament, the legislature is important. I'm not downsizing, it's important. But to say that you will do this, then further, another proviso, provided further that where the bill is reserved on grounds in Article 254(2), the decision shall be made on the understanding that mere non-conformity of the state bill with the union's policy ought not to be a ground for withholding assent. Where do we get a question of union's policy here? See, if a parliament is enact a law, and if the executive policy, and executive policy law no Ram Javed Kapoor, executive decision can be taken even in the absence of a parliamentary legislation. See, if there is an important executive policy on health, any number of issues, health, education, we govern our country by many executive policies. So if they have important consideration for the entire nation, the President will be told, don't look into executive policies, whether they are in the state of a law or not, regulation or not. So provided so and so, that a mere non-conformity ought not to be a ground for withholding assents. Provided further, that where the bill is reserved on grounds of patent unconstitutionality, the President may refer the bill to the Supreme Court for his opinion in Article 143. That's therefore mandate that the President, whenever there is a bill where the governor reserves for consideration with the President, and the President finds it unconstitutional, the President is now asked to come to the Supreme Court. Invariably, if there is now look at the number of legislation where the situation will arise. So we have an opposition to 140, a reference here today. I suppose every case of 140 will be opposed. Therefore, to us, it will be sent to the Supreme Court for his opinion under Article 143. So the President is virtually, the governor is virtually robbed of their highest levels of application of mind. When they commit a wrong, you can always find fault with that. But to say, I'll take away your discretion, your authority, your power. Therefore, you come to the Supreme Court every time there is a bill which the President thinks unconstitutional. I think this court will have more business than probably what it will otherwise have. Next, provided further that where a bill has been reserved on grounds of patent unconstitutionality, and the terms of reference from the governor involves purely legal issues, the President shall refer the bill to the Supreme Court's opinion in Article 143. Then, provided further that as and when the Supreme Court entered a decision the president shall be bound thereby and shall not withhold assent from the bill contrary to the opinion of the Supreme Court, except where such bill has been reserved for considering legal as well as political issues, and such reasons for differing from the opinion of the Supreme Court is recorded in writing. Provided further that where no reasons are recorded at any stage, where reasons that are required to be recorded, the court may presume the lack of bona fide in the action of the union of the president. Where I come under 143, under 143, the court will say whether the lack of bona fides. So I think it's again rewriting 143 itself. Provided further, as a matter of prudence, states ought to enter upon pre-legislation consultation with the union when proposing to introduce a legislation on any matter which may or ought to be reserved for consideration by the president. That's a matter for political institutional arrangement. We have the council of, union.
Mr. Sibal and Mr. Mehta have not been in a position to agree on a piece of land in Bangalore. In spite of so many suggestions given by the court.
Left to us, we will immediately agree. Our clients are unable to.
Provided further
Yes.
that a challenge to the decision of the president in withholding assent shall be challenged only by the respective state governments and only before the Supreme Court. I've not left out anything. I've been carefully trying to see that whatever the court has said.
Whether the learned attorney would be concluding today.
Your Lordship, please.
Would be concluding today.
Yeah, most probably. I think I've only two more issues. The rest will be handled by the learned solicitor.
while answering an opinion asked for by the
Give that reference. Therefore, there is no conclusive authority in that question. And there is a difference of views. 7, 5, 3, 2.
To get into the question as to whether the conclusive authority exists or not, then there is a problem. Opinion, if you are asking, it's an opinion, it's all right. No, not every question also
no.
need not be answered.
I'm only trying to point out that when you're talking about a question of law, is there a field occupied by a judgment? And therefore, once it is occupied by a judgment, the court will not enter into 140 reference at all. Therefore, in Kaveri, followed by 2G, it says there is a decision as a state of law. I'm going to probably tell you that state of law is a very important concern for the president. I have so many judgments on my table. Which is the correct state of law? 5, 7, 9, 2, 3. Therefore, if a judgment which is a bench of 2 judges, am I bound by it? I am not trying to say that you'll overrule it as a review or an appellate jurisdiction. These are all limitations which the court will ordinarily built into Article 143, where we will not ordinarily say review them. Very surprising. If you only look at a later point of time in the Tamil Nadu judgment or the Punjab judgment, we'll be easily able to convince your lordship that the line can be comfortably drawn between what on a particular set of facts the court drew some conclusion. We're not talking about those conclusions in a particular set of facts. We are talking about the state of law, the view of law. The 2G judgment therefore opens up an important door for an Article 143 consideration. And I would very humbly submit, these doors probably will be kept more and more open as and when the president comes with issues of public importance. Just 1 second, please. And also to answer an objection raised by Mr. Venugopal, that we are not referred to the judgment in the recital of the reference. He didn't argue. He didn't argue. Very. Because the 140 reference is a sui generis, and it is not akin to a pleading in a petition, writ petition or a suit. So what the president thinks is advisable for to seek a reference before the honorable court and seek his opinions on the questions referred to. There is no one particular form to be prescribed. You can't, probably the president's hands tied by forms and precedents. So it's only the ultimate test will be, will the court enter into answering a reference because of the importance of the questions raised? And if the field is, even if the field is occupied to some extent by some judgment, the court will enter into the reference and probably agree with any one of the judgments to occupy the field. That will be a later point of time.
I'll take only 10 minutes.
Attorney,
Your Lordship, please.
3 questions. Apart from the various references that you have made, you will also have to sometime answer why 145(3), though you made a request, it was not accepted, that's a different matter. That will not give rise to a need to ask for an opinion on that, a view. Second is a larger question about 142. What's the need for it? If you got an opinion on the scope of 142. Third,
Very well.
131 also doesn't arise at all.
Very
Why should we answer 131? These
No,
three questions.
We
keep
will
it in
answer.
mind.
We will answer that.
Keep it in mind. Whether we should get into those three questions, you will have to answer.
We will address your lordships on the importance of this question.
Not now.
But you want to raise the importance
Can't
of the
open
question.
up.
Because the reference has been framed after a considerable application. So the importance of the questions are arising because what a particular judgment has done is the correct view of law. Therefore, we're on the correct view of law on particularly the scheme of Articles 200 and 201. Everything hinges along the 200 and 201 scheme. So probably we'll also, when we take into the question, we'll also probably persuade that as far as that's concerned.
I'll just take 10 minutes. Lord, first of all, Lord, Article 143 Lord, needs two contingencies for the Honorable President to exist. A, the question of law has arisen, and B, a question of law is likely to arise. Lord, that is number one. And my lord, I'll read only few paragraphs from 2G judgment, my lords. The real, my lord, issue is, kindly see the importance and significance of this reference. My lord, there are in all 15 references made by the Honorable President to this court. My lord, all were with regard to a particular issue, whether the tribunal has the power, whether a particular bill is repugnant to the central legislation, etc., etc. This is for the first time where the Honorable President has felt that there is a functional disharmony which has arisen and which will arise because there has been no authoritative judicial pronouncement except, my lord, the judgment in question in case of Tamil Nadu, where one organ of the state fixes time schedule for the another organ of the state and also provides for the consequences of deemed assent. My lord, that is the reason why, my lord, this judgment, this reference itself is a sui generis reference where the Honorable President is pleased to request your lordships to advise her that there is a constitutional problem, a constitutional functional problem, how the President would act, how the governor of the state would act, what are the contours of Article 200, 201, and my lord, the President's power of assent under Article 111. Now, please see, my lord, in case of 2G, my lord, there are two distinct factors and still the court has laid down the law that reference is maintainable. A, my lord, if your lordships can see, my lord, the question, your lordship did not read the question. The questions which were referred for your lordship's advisory jurisdiction, one of the question was whether judgment of two honorable judges reported in so-and-so lays down the correct law. It was a direct, my lord, as if it was an appeal. So the principal argument against the maintainability was with regard to whether this court would exercise one advisory jurisdiction virtually sitting in appeal because one of the questions was so framed. Lord, now in this context, Lord, please come to para 48.2, Lord, of the judgment in 2G. Lord, that is page 8181. Volume 5.21, page 8181. 48.2, my lords. Lord, your lordships would kindly bear in mind, Lord, your lordships do not generally go into a judgment already decided, not as a jurisdictional issue, that 143 does not permit you to do that. It is a self-imposed restriction that while exercising advisory jurisdiction, we will not go into the question of whether one particular judgment is rightly decided or wrongly decided. But in 2G, my lord, your lordships have said that even that is permissible. Now, please come to page 48.1 and 48.2. 48.2, my lord. The second limitation, a self-imposed rule of judicial discipline. Your lordships have, my lord?
Yes.
The, Lord, it would be page
8181.
8181, my lords. The para 48.2, the second limitation, a self-imposed rule of judicial discipline, was that overruling the opinion of the court on a legal issue does not constitute sitting in appeal, but is done only in exceptional circumstances such as when the earlier decision is per incurium or delivered in absence of relevant or material facts, or if it is manifestly wrong and capable of causing public mischief. For this proposition, the court relied on the judgment in Bengali immunity case, whereas it was held that when Article 141 lays down that the law declared by this court shall be binding on all courts within the territory of India, please note this, my lords, it quite obviously refers to courts other than this court, and that the court would normally follow past precedents laid down in that judgment. In fact, overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. Your lordships can say, if persuaded, that Tamil Nadu judgment is not laying down the correct law. It's not your lordship's appellate power, is your lordship's inherent jurisdiction, inherent power. This inherent power can be exercised as long as previous decree vis-a-vis in a list inter partes is not affected. It is the attempt to overrun the decision of a previous case that is problematic, which is why the court observed as under, my lord. Please now come to 45, para 45, lords. Where the court distinguishes decision and the point of law decided in that decision. My lord, page 817, my lord, and two paras, my lord, I am done. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri.
Paragraph?
Para 45. 8179. And two very interesting paras, my lord, which generally go unnoticed, my lord, but I must place for your lordship's consideration. Para 45. My lord, their argument was that one of the questions referred by the Honorable President is whether this judgment is right or wrong. Can you do that? In answer to that, my lord, this court, my lord, speaking in this reference judgment says this, 45. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri 2, which according to him prohibits this court from overruling a view expressed by its previously under Article 143.1. We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Now, please, Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these two situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draw a difference between the two by using the word when further this court overrules the view of law after discussing the decision. Then 47. Therefore, the reference in para 85 of Kaveri to decision and view of law must be severed from each other. The learned judge observes that in case of a decision, the appellate structure is exhausted after the pronouncement of the Supreme Court. Therefore, the only option left to the parties is to review, etc. Now, please see Classett MD. However, this is important and I place respectful emphasis. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced in the course of reaching the decision. Justice Sawant clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power when he says, that is again in a reference. Justice Sawant is deciding whether 143 would cover overruling a judgment and says, which is affirmed in 2G, that yes, we can overrule the question of law decided in the judgment. Lord, now kindly see two paragraphs and they are very interesting paragraphs. Para 61 and 62. Lord, because this, Lord, it appears that has been a consistent tendency of opposing reference of the Honorable President, and so far in our history of this constitutional democracy, there are only 15 references made by the Honorable President on individual bill or individual facts, etc. Please see 61. From the aforesaid, it is, your lordships have.
Yes.
8187. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modifications may be stated as one of the modes or methods of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one cannot be oblivious of the fact, etc. But see 62. It is of some interest to note that almost every reference filed under Article 143(1) has witnessed challenge as to its maintainability on one ground or the other, but all the same, references have been answered except in Muhammad Ismail Faruqi, that Babri Masjid case, which was returned unanswered, mainly on the ground that the reference did not serve a constitutional purpose. Basically, the court said, we are not experts on the subject of adjudication which the president has referred. Kindly, my lord, and your lordships are aware of the fact that the highest head of the executive is seeking your lordships' guidance that there are judgments of 5 judges, 2 judges, 3 judges, 7 judges, and it has created a constitutional functional problem for us. How would the president govern?
You can't expect the Supreme the conflict of judgments.
I'm not.
In an opinion.
Functionality, what would be the
larger bench.
What would be the contours of Article 200? Am I bound by the 3 months deadline? Am I bound to record reasons when the Constitution doesn't provide? Am I bound to intimate everybody? And is it permissible for the court to say that every state will come to the court? Lord, we are not, my lord, we will be addressing this on the merits of the case. But, my lord, there has to be a difference and deference when, my lord, the court is dealing with constitutional functionaries, which is a part of separation of powers. And therefore, my lord, one of the questions raised is, could the bench of the strength which decided the question without setting aside their judgment, my lord, your lordships, my lord, is requested to opine, have decided this question in light of the constitutional mandate under Article 145(3). And despite a request being made that please refer to the larger bench, this is one of the questions being answered. This, my lord, question is a sui generis question in itself, my lord, as compared to other questions. My lord, therefore, my lord, we'll address your lordships on merits, and my lord, we'll satisfy your lordships about the, we will assist the court, my lord. This is not a list to be decided.
Both
Yes.
sides probably are very clear that we are in advisory jurisdiction.
Yes.
We are not sitting here as appellate forum.
My lord, sir.
You are also saying, they are also
Yes, yes.
ending that. So it's very clear.
Yes.
You are absolutely right. 143(1), question of law has a reason or may arise in future. We will answer that.
Correct.
Whether a question of law first has a reason, and if a reason, how it is to answer, right?
What are the contours, etc.? Yes.
That process, the court can render an opinion that a judgment does not lay down the correct statement of law.
Your lordship.
Does not lay down a correct statement of law. But that will also not technically amount to overruling the judgment. It will be a different opinion. For overruling, you might be required to refer.
My lord, the 2G judgment, my lord, if I take your lordships.
Maybe
My lord, 2G judgment and my lord, in Kerala bill, I think 7 judge bench of this court, my lord, has said that in a reference, answering the reference on a question of law, on a proposition of law, your lordships can even overrule the judgment.
I mean, it's that part can be checked. Otherwise, yes, we can always declare
Lord,
that.
para 56, immediate, para 56 of 2G. 50. Para 50 and 56. My lord, just to answer your lordship's question. Kindly, my lord, come to para 50 and 56. My lord.
Yes.
Lord, 8182. para 50, my lord, 8182, your lordships have, my lord, which relies upon special courts bill. That's seven judge, my lord, bench judgment.
Which volume is that?
Para 5, my lord, it starts with finally. I'm sorry, it is volume 5.21, page 8182. Directly answering, my lord, what my lords, my lord, were pleased to put to me. Does your lordships get, my lord?
Yes.
My lord, Justice Vikramnath gets 50. But this is 2G.
I got it first, huh?
But your lordships are always, my lord, more techno-savvy than the rest of us, my lords. Finally, a seven-judge bench of this court has clearly held that this court, under Article 143(1), does have the power to overrule a previous view delivered by it. Chief Justice Chandrachud in Special Courts Bill.
You can be overruled, but not a decision.
Correct.
That's right.
That's what,
But
Clarify.
please read, my lord, what the seven judges say. We are inclined to the view that though it is always open to the court to re-examine the question already decided by it and to overrule, if necessary, the view earlier taken by it, insofar as all other courts in the territory of India are concerned, they ought to be bound by the view expressed by this court, even in the exercise of its advisory jurisdiction under Article 143(1). Then, my lord, para 56, my lord, kindly have a look at para 8185, my lord, para 56.
one.
Even legislatively, we overrule a judge.
You can just say in case of saying this is the VP privileges case. Basically, it's overruled 6 judges in exemption issue. The fundamental rights in national privileges.
It's a wrong law. My lord, I'm not reading it. My lord, Keshav Singh judgment, your lordships are aware, my lord, that Uttar Pradesh, the dispute between, my lord, the assembly and the, my lord, there was some privilege issue where, my lord, the reference was made. And in that, my lord, the honorable court overruled the view taken that this judgment does not lay down correct law. Otherwise, my lord,
Affirming or overruling a view definitely is permissible.
Certain-
Otherwise, how will you exercise 143?
140.
Can't exercise that. That is understandable.
Even the legislative process also.
But
An act cannot take away the mandamus, the chief was saying. Same independence of judiciary.
pardon.
No.
Oh, that's a separate. Yes, my lord, we will be. My lords have taken the view, my lords. My lords in that extension of
Yes,
certainly, my lord.
Justice Nath and
No, we are not, fortunately, my lord, faced with that situation. We are possibly, my lord, if I may say so, faced with a converse situation.
Just one submission for your lordship's kind consideration.
May I be
My
heard?
lord, which is,
Only,
Which-
Mr. Salve wanted, my lord,
Yes.
5 minutes.
No, I want
Can I just-
5 minutes by the clock.
Just Mr. Let Mr. Kaul finish after minutes.
my lords, 2G, as fell from my lords, emphasizes the distinction between decision and a view of law, and a review and a reference, and goes on to say that a review or a decision deals with the lis inter partes. A view of law is what is not eternal, malleable, and is subject to overruling, clarification, and modification. And that is why, my lords, in para 101 of the 7 judges' judgment, which is relied on in para 50 of the 2G judgment, they say we can overrule. And overrule, as felt from my lords, is not in exercise of either appellate jurisdiction or appellate jurisdiction being vested by a presidential reference, which can never be done. It is an exercise of the inherent power conferred on the Supreme Court to look into it and overrule it. And that is the reason why it was done, and 2G referred to it. refers to Kaveri. In fact, my lords, Kaveri, subject to correction, does not deal with the 7 judges' decision in the manner it ought to have, which is para 101, which talked about that 143(1), you can exercise the jurisdiction to overrule. And that ratio can be clarified. So the fundamental error is to say that you're vesting an appellate jurisdiction in this court while exercising its jurisdiction, while answering an opinion asked for by the president. It is not an appellate jurisdiction that your lordships are exercising in the matter. And my lords, as far as a reference is concerned under 143, the president's opinion and satisfaction has not only been held to be non-justiciable, has been the final arbiter as far as the issue is concerned of whether a question arises. Is that question of such public importance that the opinion of the Supreme Court is needed on it? That is where, that is the decision. Then whether your lordship chooses
That's
to...
not be correct, Mr. Cole.
Yes.
143(1) talks of may, and
Yes.
that's why 143 to talk of shall.
Yes.
In shall, we are bound. We
Yes.
have to answer it because that will be applicable to 131. In 143(1), first we will determine that is there a constitutional question of law has arisen